Thank you, Mr. Chairman. And Mr. Secretary, thank you for being here. Read nothing into the fact that I'm on your extreme right here today. But I do want to talk to you about something that I think that we have some bipartisan support to address. And recently, just last month, FSOC came back with some regulations dealing with transparency with regard to systemically important financial institutions. And while I think it's a step in the right direction, I'm concerned that it didn't go far enough. They did not address concerns about how to mitigate systemic risks. It did not create a process that would reduce potential threats to the financial system by allowing a company or its primary regulator to identify risks before designation. For example, today's law as it exists today, a non-bank financial institution that is being considered as a SIFI doesn't really have any guidance to be made aware that they are going to be in this particular situation. They don't have any mechanism that FSOC can provide them with about their profile to help them get out of it. We've got no notice. And my concern is that while transparency is very important, we've got to make sure that if our ultimate goal is to remove them from a SIFI designation, that they have the opportunity by way of notice, by way of guidance in order to get out of there. And so I have some proposed legislation that has some bipartisan support that I will be filing here shortly, but it addresses the method and manner by which FSOC would deal with systemically important financial institutions, specifically non-bank ones. And wouldn't you not agree that FSOC's primary focus should be to identify and ensure systemic risks are addressed rather than simply delivering a non-bank entity to the Federal Reserve for yet another undefined regulation?
Congressman, I think that if you look at the new procedures that we adopted, they were very much designed to engage with firms earlier.
And would you not agree then that codifying these rules may be in a good position? Because your successor may take a different position, and obviously this seems to be the step in the right direction.
I think if you look at the evolution, I mean, FSOC is a 5-year-old organization. It had a good initial set of rules. It now has a refined approach. There was a lot of communication going on even before the new rules changes, so it's not as hard of a change as.
But I guess you would agree that the rule change.
I don't think there's any going back. I think these things move forward, not
to a greater degree of transparency and procedure. Would you not agree?
Yeah. Look, I think we have tried since I've been chair of FSOC on multiple occasions to expand the transparency, to increase the communication. And we will continue to look for opportunities to do that. I don't think that.
But returning them to the Fed for regulation when it may not be their primary regulator, that might not be the best way.
Well, look, the process of designation is one where the responsibility on FSOC is to determine whether or not there's a systemic risk.
Correct.
The remedy is prescribed in the statute that the Fed supervises if that determination is made.
And with regard to, let's say, for example, international standards, we've got FSOC dealing with the global systemic financial institutions, and I think that there's been some concerns that, for example, the independent insurance expert on FSOC said that different types of non-bank financial companies may be receiving disparate treatment both in the Council's analysis and processes. Is this something that you would agree, and we might need more aggressive representation on behalf of the insurance industry when dealing with these global capital standards involving insurance companies?
I think that our representatives have been advancing the interests of the U.S. in this process effectively. There's been a lot of communication between Federal and State officials, between private sector.
But understanding the impact that it could have on our domestic insurance market if we're having to impose upon them international standards, which we had a chance to preempt had we had a little bit more aggressive representation.
Yeah, I think that the representation is appropriate. The consultation is appropriate. There's obviously a lot of interest and a lot of consultation.
Lastly, I want to address one thing with regard to asset managers. You know, that the American Action Forum did a study in 2014 and found that additional capital requirements on asset managers could cost American retirees at least $100,000 in potential savings accumulation. And they get this because they say that now with these increased capital standards, which is as much as 8%, and most of the people who invest in these funds are saving for retirement, saving for college funds, this has a significant impact on mom and dad and grandma and grandpa that are trying to set aside for the future. Does FSOC take into consideration the impact that this has on the bottom line of these individual savers?
Okay, the way FSOC goes through the process of determining whether or not a firm presents the kind of financial stability concerns is by going through an analysis of what the firm's
And they should take that into consideration.
That's the principle.
Because we want to protect the consumers and make sure they
But
get
just to be
return
clear,
on
in
investment.
asset managers, as we went through the process and came to realize that there were more concerns about specific activities than necessarily the firms that were being looked at, we also took a step back and shifted the focus to look primarily at activities that may need attention. I think that shows the openness of the
I appreciate
process
that.
to learning as we go through.
Time.